The Section 115, Subsection 1, Act 51 of 1977 statement, wherein he stated that I place all the elements of the offences in dispute and specifically deny handing a firearm or ammunition to Mr. Malema at any stage, and Advocate Matthews had then stipulated the factors mentioned in the further particulars by the state, which the court had placed on record. It is also submitted by Advocate Matthews that he agrees with the state's submission that if one observes the clips, accused 2 was unaware of any shots that might have been fired. The state also conceded that it is bound by the further particulars provided to the defense by the state. The firearm in question was not in East London on the day in question, and that Larry Mavundla was called by tactical security services from Gauteng to Durban, where he had handed the CN SPA 249-14, including a 9mm Glock firearm, over to presented it to Colonel Jansen. It was not taken by Colonel Jansen, but I will get to that. Further, that the so-called viral footage was not proved as the original device and was never traced or produced in court. The second video footage being the Gearhouse Company footage, it was highlighted by Advocate Matthews that the video footage evolves around it being ruled or deemed as real evidence or as documentary evidence, and that the distinction between the two is of great importance. Real evidence only requires relevance, the other requires originality and authenticity. Let me try, I'm going too fast. Authenticity, before it may be ruled as admissible. In essence, that there is no evidence before court that accused 2 committed any of the alleged offences, and read in the light of the state's concession in this regard, apply that accused 2 be acquitted to all counts. I'm not going to deal with the address regarding the application for accessory after the fact. Therefore, the court will now, as it is obliged to do so, deal with the law applicable in any matter, not just the matter before court, that any court must consider and place on record the law and what is required of a court to do in arriving at a just decision. It is well known in a criminal matter that the burden rests on the state to prove the guilt of an accused beyond reasonable doubt, no more and no less. This is clearly stated in State v. Jackson, 1998, 1 SACR 470, Supreme Court of Appeal at 476. It is further required that a court must consider all the evidence, and I'm saying all the evidence, hence it took 2 days to place all the evidence on record, to arrive at the factual basis determined by evaluating all the probative material admitted during the course of the trial. The case law stated in Stellenbosch Farmers Winery Group Limited versus Mattel ET and others 2003 1 SA 11 Supreme Court of Appeal decision is clearly outlined and thereafter followed by numerous decisions up to date. And therefore, to come to a conclusion on the disputed issues, a court must make findings on the credibility of the various factual witnesses, their reliability, and also the probabilities of each case. Findings regarding credibility of a witness, namely the veracity of the witness demeanor, in the view of the court, not as important whilst in the witness box. Any bias, latent and blatant, and internal contradiction in his evidence. It further requires an analysis and evaluation of the probabilities or improbability of each party's version on each of the disputed issues. Once having done so, the court is required to determine whether the party burdened with the onus of proof has succeeded in discharging it. It is therefore the correct approach to weigh up all the elements which points toward the guilt of the accused against all those which are indicative of his innocence, taking proper account of inherent strengths and weaknesses, probabilities and improbabilities on both sides, and having done so, to decide whether the balance weighs so heavily in favor of the state as to exclude any reasonable doubt to the accused guilt. In State v. Saban and another 1992, 1 SASV 199 Appellate Division, I should also add, it's not old, it is a case law. This dictum in Saban has been followed in judgments and by courts up to date. Where the versions of the state and the defense are contradictory, the relative honesty of the two conflicting versions is indeed of great importance. Before, however, a finding as to the objective truth of the version and the falsity of the other can be reached, not only the honesty of the version has to be considered, but also and more particularly the reliability thereof. What has to be proved is the truth of the owner's bearer's version, and not merely the honesty of the witnesses who put it forward. Honesty and objective reliability are not synonymous. It has been stated in various case law matters that proof beyond reasonable doubt does not equate to proof beyond a shadow of doubt. If a remote possibility in his favor, which can be dismissed with a sentence, I quote, "Of course it is possible, but not in the least probable," unquote, the case is proved beyond reasonable doubt. Reference is made to State v. Gadebe, 1991, 2 SACR 166, a then Transvaal decision, deals extensively with the burden of proof. The test remains whether there is a reasonable possibility that the accused version or evidence may be true. In applying the test, one must also remember that the court does not have to believe his or her story. It is sufficient if it thinks there is a reasonable possibility that it may be substantially true. The case law is clear that no onus rests on the accused to convince the court of the truth or any explanation he or she might give. If he gives an explanation, even if that explanation be improbable, the court is not entitled to convict unless it is satisfied not only that the explanation is improbable, but that beyond any reasonable doubt it is false. If there is any reasonable possibility of his explanation being true, then he is entitled to his acquittal. I repeat that in all the case law pertaining to reasonable doubt, the one common denominator remains that beyond any reasonable doubt cannot be precisely defined, but it can be said that it is a doubt which exists because of probabilities or possibilities which are considered reasonable on the grounds of general human experience and knowledge, and therefore it does not equate to proof beyond the slightest doubt. A court does not have to be convinced that every detail of an accused version is true. If the accused version is reasonably possibly true in substance, the court must decide the matter on the acceptance of that version. Of course, it is permissible to test the accused version against the inherent probabilities, but it cannot be rejected merely because it is improbable. It can only be rejected on the basis of inherent probabilities if it can be said to be so improbable that it cannot reasonably possibly be true. It also remains a fact that there will need to be an evidential basis for suggesting that the evidence of a specific witness may be unreliable. An evidential basis does not include mere suggestions by cross-examining counsel. The issues pertaining to the matter before court that needs to be addressed is, firstly, I will deal with the evaluation of police statements. This is relevant in the matter with regards to as far as it pertains to Captain Govender, Colonel Mzuko, where cross-examination was extensive, and the following law is cited in this matter and followed to date. In Malafadiso versus S 2003 1 SACR 583, Supreme Court of Appeal 593 to 604, stated clearly that a discrepancy in a statement caused by one sentence only could be interpreted in one of two ways. It must be read in the context of the whole statement. In this instance, I add, it must be read in the context of the question or the statement posed prior to the witness answering. Therefore, the court must ascertain what the witness meant to say in order to determine whether there was a discrepancy and the extent of the discrepancy. This evaluation includes the circumstances in which the versions were given, reasons for the discrepancies, the effect of the discrepancies on the witness's credibility, and whether the witness has sufficient opportunity to explain the discrepancies. Lastly, the witness statement to the police must be weighed up against the witness's viva voce evidence in court. In State v. Pitto 2005 1 SACR 971, a court should determine whether he or she was satisfied, and this is also important in this matter, that the court is obliged to determine whether the witness was satisfied with the correctness of the contents of the statements as far as it pertains to previous statements to the police. Evaluation of contradictions. I will deal with that concept. Contradictions per se do not lead to the rejection of a witness's evidence. They may simply be indicative of an error, and the law is clear that not every error made by a witness affects the credibility. In each case, the trier of fact has to take into account such matters as the nature of the contradictions, their number and importance, and their bearing on other parts of the witness's evidence. No fault can be found with the conclusion that what inconsistencies and differences there were of a relatively minor nature and the sort of thing to be expected from honest but imperfect recollection, observation and reconstruction. One may add that such contradiction points away from the conspiracy which may be relied on. It is also a well-known concept in our law that where a witness has been tied down by repeated cross-examination to make estimates for an example with regards to times, etc., and in the process contradicted himself, it may be a misdirection to attach much importance to those contradictions when elicited by counsel and results in concessions made to ensure that it indeed comes to an end. Sorry. At Hartek Jones Treasure Architects CC versus University of Fort Hare 2002 5 SA 32, an ECD decision, states that a concession, like any other evidence, may either be conclusive or count for nothing. Witnesses make concessions for any number of reasons, sometimes because the concession is in fact warranted, sometimes because they are confused or tired, or because they do not understand the effect of the concession, sometimes in circumstances where they are asked to attach their interpretation on certain events. The concession, like any other viva voce evidence, must be weighed by the court in the light of the totality of the evidence before it and the probabilities revealed thereby. This matter also requires the assessment of corroboration by court. The leading case law, in my view, still remains State v. Gentle 2005 1 SACR 420 SCA decision at 430. It must be emphasized that by corroboration it refers to other evidence which supports the evidence of the complainant and which renders the evidence of the accused person less probable on the issues in dispute. What is required is credible evidence which renders the state's version more likely and the accused version less likely. In State versus Van Aswegen 2001 2 SACR 92 SCA decision 101 D2E, the following approach was cited and adopted in State versus Van der Meiden 1999. One is SACR 447 at W, close bracket. The proper test is that an accused is bound to be convicted if the evidence establishes his guilt beyond reasonable doubt, and the logical corollary is that he must be acquitted if it is reasonably possible that he might be innocent. The process of reasoning which is appropriate to the application of that test in any particular case will depend on the nature of the evidence which the court has before it. What must be borne in mind, however, is that the conclusion which is reached must account for all the evidence. Some of the evidence may be found to be false, some might be found to be unreliable, some might be found to be only possibly false or unreliable, but none of it may simply be ignored. In this regard, also see State versus Crossberg 2008-2 SACR 317 Supreme Court of Appeal at 157. It has been stressed in various case law that the importance of the principle that evidence must be assessed holistically is also noted by this court. The matter also warrants a reference to State versus Traynor 2003 1 SACR 35 SCA decision paragraph 9. A conspectus of all the evidence is required. Evidence that is reliable should be weighed alongside such evidence as may be found to be false. Independently verifiable evidence, if any, should be weighed to see if it supports any of the evidence tendered. In considering whether evidence is reliable, the quality of that evidence must of necessity be evaluated, as must be corroborative. It must be therefore corroborative evidence, if any. Evidence, of course, must be evaluated against the onus on any particular issue or in respect of the case in its entirety. It should also be noted that the high standard of proof universally required in civilized systems of criminal justice is a core component of the fundamental right that every person enjoys under the Constitution to a fair trial. It is an inevitable consequence of living in a society in which the freedom and the dignity of the individuals are properly protected and also respected. Therefore, convictions based on suspicion or speculation is not permitted. The court also needs to mention the chain of custody, being the document of activities, or explained as being the document of activities performed on digital evidence by recording its control, transfer, analysis, and disposition during criminal cases. It is crucial to maintain a complete chain of custody report to ensure that evidence is not compromised at any point from the time of collection to its court presentation. It shows who has collected and accessed digital evidence when the evidence was transferred. Typically, a chain of custody report must include the following information to maintain a detailed log of activities performed on digital evidence: the name of the investigator or police officer who collected the evidence, the time and date when the changes have been done in the evidence, description of evidence, relevant serial numbers or case numbers, activities performed on the evidence such as evidence has been uploaded and viewed. There is no need to say that digital evidence is a key element in solving criminal matters. In order to prove the guilt of an individual or not, prosecutors must therefore justify that the evidence presented in the court is as original as collected at the crime scene. Therefore, the chain of custody is more important than digital evidence itself, as it proves the integrity of evidence in court. What is required is a detailed log of activities performed on each evidence file through a comprehensive chain of custody report. A further aspect that the court needs to place on record pertains to the evaluation of expert witness testimony, and I emphasize the requirements. The court must be of the opinion that the person is an expert and competent to testify as an expert. The expert testimony must comply with 3 basic requirements: the basis for the expertise and the expert's qualifications, experience and expertise, and specifically knowledge must be put before the court. The basis for the opinion and reasons for the opinion must be put before court, which was used or which was based on the facts in the case. The opinion of an expert must not displace that of the court. The prime function of an expert is to guide the court to a correct decision on questions falling within the expert's specialized field. It is generally required from experts to comply to high standards of accuracy and diligence when they conduct inquiries or perform tests, in this instance being ballistic, fingerprints and DNA. A mere reference to test books which they have consulted is inadmissible hearsay. The expert must have personal knowledge of the suspect. I emphasize personal knowledge of the subject being the exhibit. State versus Engelbrecht 2005 to SACR 41 in brackets WLD bracket. It cites that courts frequently turn to persons with expertise and skill for assistance. The relevant principles applicable to the admissibility of opinion evidence by experts have been set out in numerous authorities. Firstly, the matter in respect of which the witness is called to give evidence should call for specialized skill and knowledge. Secondly, the witness must be a person with experience or skill to render him or her an expert in a particular subject. And thirdly, the guidance offered to the expert should be sufficiently relevant to the matter in issue to be determined by court. Fourthly, the expertise of a witness should not be elevated to such heights that the court as to replace the court's own capabilities and responsibilities. And fifthly, the opinion offered to the court must be proved by admissible evidence, either facts within the personal knowledge of the expert or on the basis of facts proven by others. The sixth one being the opinion of such a witness must not usurp the function of the court. The evidential value of the expert's testimony will depend on the expertise of the expert with reference to qualifications, experience, knowledge of the subject, as well as the reliability of the evidence, including corroboration of the evidence. The opinion should be accurate, impartial, and objective. The court should therefore evaluate whether the witness is in fact an expert in the field and whether the expert's opinion is based on sound reasons, which is based on the facts presented before court, including accuracy and reliability of the opinion, objectivity and impartiality. Further, whether the court's factual findings in the case supports the expert's opinion. Again, accuracy of opinion and to the extent to which the expert's evidence is undisputed and or corroborated by factual findings, thereby the reliability of the opinion. And further, whether the opinion is objective, impartial, and safe to rely on. Just a minute. The matter before court, even if it's the media. Oh no, I was going to say the media, if it's them, they must leave now. You took responsibility, so I'll leave it at that.
I honestly don't know how this thing can go.
I wouldn't know. As stated, In the matter before court, a discussion pertaining to circumstantial evidence is required. The difference between direct and circumstantial evidence is important. Various case law states that circumstantial evidence is not necessarily weaker than direct evidence. In some instances, it may even be of more value than direct evidence. Inferences are drawn from circumstantial evidence, and in this process, certain rules of logic must be followed. It is also required that the court should always consider the cumulative effect of all the items of circumstantial evidence. It is also a well accepted principle that the court should not consider each circumstance in isolation and then give the accused the benefit of any reasonable doubt as to the inferences to be drawn from each single circumstance. This approach can also be put differently. The state must satisfy the court not that each separate item of evidence is inconsistent with the innocence of the accused, but only that the evidence taken as a whole is beyond reasonable doubt inconsistent with such innocence. And now I know citation of the following matter always elicits questions. The well-known dictum in R versus Blom, 1939 AD 188, has been cited with approval since then in all case law pertaining to circumstantial evidence up to date and remains the principle or the basis of the evaluation of circumstantial evidence. This dictum has been cited with approval in cases, example, S versus Steinberg, 1983, 3 SA 140 Appellate Division, State versus Van As, 1991, 2 SACR 74 Witwatersrand, and in State versus Reddy and others, in brackets 416/94, in brackets 1996, end of bracket ZA Supreme Court of Appeal decision handed down 28 May 1996. The court will now deal with the evaluation of circumstantial evidence, including the cardinal rules pertaining thereto. As stated, evaluation of circumstantial evidence in State versus Reddy and others, citation on record, states clearly that in assessing circumstantial evidence, one needs to be careful not to approach such evidence upon a piecemeal basis and to subject each individual piece evidence to a consideration of whether it excludes the reasonable possibility that the explanation given by any accused is true. The evidence needs to be considered in its totality. It is only then that one can apply the often quoted dictum in R versus Blom citation on record, where reference is made to the two cardinal rules of logic, which cannot be ignored. These are, firstly, that the inferences sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts should be such, I quote, that they exclude every reasonable inference from them save the one sought to be drawn. This is well worded in the remarks of an also very old case law, Davis, AJA in R versus de Villiers, 1944, AD 493 at 508. The court must not take each circumstance separately and give the accused the benefit of any reasonable doubt as to the inference to be drawn from each one so taken. It must carefully weigh the cumulative effect of all of them together, and it is only after it has been done so that the accused is entitled to the benefit of any reasonable doubt which it may have as to whether the inference of guilt is the only inference which can be reasonably drawn. To put this matter in another way, the state must then, as stated, satisfy the court that each separate fact is let me rephrase, as stated, the state must satisfy the court not that each separate fact is inconsistent with the innocence of the accused, but the evidence as a whole is beyond reasonable doubt inconsistent with such evidence. A number of circumstances, each individually very slight, may so tally with and confirm each other as to leave no room for doubt of the fact which they tend to establish, though each taken by itself weigh but as light as a feather. However, join them together, you will find them pressing on an individual with the weight of a millstone. It is further described that in cases surrounding circumstantial evidence and circumstantial evidence alone, evidence varies infinitely in its strength in proportion to the character, to the variety, the independence one of another, and one might describe it as a network of facts cast around an accused person. That network may be that strong as it is in part, and it may also leave gaps and may then allow the accused person safe passage. It may be so close, so stringent, so coherent in its texture that no efforts on the part of the accused can break through, and it may come and it may also come to nothing, and or on the other hand, it may be absolutely convincing. The law does not demand that you should act upon certainties alone. We often ought to act upon just and reasonable convictions founded upon just and reasonable grounds. The law asks for no more and the law demands no less. I further refer to State versus Kwanda, 2013, 1 SACR 137, Supreme Court of Appeal, where Mareje stated that such an inference is only justified where the state has established facts from it can properly be inferred by a court. Now, in the instance, and as I've stated, in an attempt to summarize the facts in dispute, it basically comes down to whether accused one fired a real firearm on the day in question and whether such firearm was provided to him by accused two. To an certain extent, also whether Colonel Mngwadleka correctly linked the cartridge found to the firearm CN SPA 24914, the chain evidence regarding the gearhouse footage, since the laptop used on the said evening had been stolen, and whether the state proved the authenticity of the now known called viral footage, and whether the CN SPA 24914 was in East London on the said date, and it all amounts to whether the firearm in effect was fired on the night in question was a real gun or a toy gun. That in essence is the pertinent question that this court needs to answer to today. The common cause facts in a summary form is that it is common cause that the EFF hosted an event being their 5th birthday celebrations at Sisa Dukashe Stadium, Mdantsane, East London on 28 July 2018. Mr. Malema and Mr. Snyman were both present during the event. The event was recorded by Gearhouse Company. At some point during the celebrations, Mr. Malema fired shots in the air, be it with a real or toy gun. Therefore, the court is not saying it is a real or a toy gun. Merely its common cause, or that a firearm or toy gun was fired. Shots were fired. That point. Full stop. Mr. Malema confirmed in his evidence in chief and through instructions by advocate holders that he fired shots, however, with a toy gun. I mention this as common cause since it is evidence of the accused one himself that he fired shots. That the shots fired by Mr. Malema with a said object emits a muzzle flash. That Larry Mavundla was present on the day in question. Further, that VIP protectors were assigned to, I quote, body watch, unquote, Mr. Malema, two being from the Eastern Cape and the other from Pretoria. That a cartridge case was picked up after the event, or that a cartridge case was picked up at the stadium on the Monday morning, and the event was held on the 28th of July 2018, a Saturday, and they left about 2 a.m. the following morning. The said cartridge was picked up by the cleaning staff of the stadium and grounds on the Monday, being the 30th. The tactical security company was registered and that one, Mr. Mduli, was the responsible person at the time, however, was ill and in hospital at the time of the event. All firearms were dispatched in batches by accused 2 for ballistic testing. All firearms were returned to the above-mentioned company. That an audit of the registers of tactical security was inspected, which commenced on Friday the 3rd of August 2018 and continued on the Monday 6th August 2018. At that stage, where SABC was about to leave, Mr. Larry Mavundla arrived with 2 firearms, a 9mm Glock handgun and a rifle SPA 249-14, and it is said by the defense saying that the firearms was called in to be provided to SABC for ballistic examination. Further, all registers of the company was in order and all firearms, be it handguns or rifles, were accounted for. I must emphasize when I say accounted for, it is indeed accounted for in the register as inspected by Colonel Jansen in the KZN office, indicating the amount of rifles being booked out and the reference made of the 2 that was returned. I hope you understand the way I am stating this. Therefore, the ones who were booked out, save for the 2 presented, I accept it was booked out per the register, but that was not returned on the same time, at the same time. Further, at the stage where SABC was about, okay, I've stated that, sorry. As per Exhibit L, statements by Warrant Officer Small being a confirmation that Tactical Security Services was found to be compliant with all requirements in respect of all 221 firearms and ammunition. The premises was also found to be in compliance of legislation as to how and where firearms and ammunition should be kept. Accused 1 and 2 are known to one another since 2008. Mr. Malema uses the services of tactical security for his personal protection. Now the court will venture on the following. Much has been said regarding the viral clip, the viral footage being clip 3. I want to deal with the clip as follows, and that is what facts remain proved on record should the court not include the viral footage. 1. That the event stipulated on record occurred on the date, time and place mentioned on record. The footage is not needed in that regard. That Mr. Malema is on the stage and fires an object which resembles a gun or rifle in the air and it emits muzzle flash. that Mr. Snyman was present on stage, the 5 statements placed on record by the defense for accused 1, a cartridge was picked up on the grounds of the said stadium and handed to the supervisor, who in turn handed it to Captain Swart, who sealed the cartridge in an exhibit bag. All state witnesses called, being the employees of Gearhouse Company, remains facts on record, and that they recorded the event, that after checking the recording on the laptop, it was downloaded on a hard drive, and also further checking that it has indeed audio. Thereafter, the laptop is cleared for further events and the hard drive is kept intact. An inspection was done by SABC of the premises of Tactical Security Services and all registers were corresponding. The CN-SPA 24914 is the property of Tactical Security Services. The said firearm was booked out according to the registers of Tactical Security to Mr. Larry Mavundla. Mr. Mavundla was in East London and attended the event, and he was also said to be on stage. Therefore, it is also without reference to video clip 3 that he had left the firearm in Gauteng. Therefore, he was no longer in control of the firearm that was booked out to him for his use when necessary. Accused 1 departed from East London on 30 July 2018. A compliance letter in respect of tactical services as mentioned. Therefore, in essence, all of the above facts remain without needing the viral footage to support these facts. Further, all firearms checked by the ballistic unit as per batches received and returned remains unchanged, that a toy or movie gun may emit muzzle flash. DNA and fingerprints were not linked to Mr. Malema or, if tested, are to accused 2. Therefore, again, the only aspect to be determined is whether the rifle fired by Mr. Malema was a real firearm or not, and the court is of the view that the viral footage is not needed to enable the court to arrive at a finding in this regard. As a side remark, it should be noted that the very same viral video footage was used by the defense to indicate certain factors they wanted to be placed on record, and in the same breath, the court is asked to rule that the viral video footage is inadmissible based on the fact that the originator of the said footage was not traced and called as a witness. Therefore, even though the court ruled the said footage as real evidence, as it is relevant, but it should be excluded as it was not authenticated. This leaves the question as to why the defense relied on the footage during their cross-examination of the state witnesses to emphasize certain factors or facts, and it was also used by the defense during the presentation of the defense case in respect of accused 1. Further reasons that remain without reference to the viral footage is the Gearhouse Company footage was downloaded on a hard drive which was kept safely under lock and key by Mr. Singh. He was the only key holder of the said safe, and it was only unlocked when the officer from ballistic unit arrived. The procedure thereafter as to the downloading by the various individuals placed on record as per facts was confirmed in evidence that it is indeed the recording recorded by Gearhouse, and that the snippets that was viewed regarding clip 1 and 2 was indeed part of the recording that was recorded. I will admit and mention the Gearhouse footage is not as visible as the viral footage, but in this regard Therefore, the gearhouse footage is ruled as real evidence, it is relevant, it was authenticated, and therefore it is ruled admissible. With regards to the viral footage, I've stated the facts which the court will rely on without giving any real regard to the viral footage, and no further finding is required regarding the said footage. Now, please bear with me. As I said, I tried to summarize all in a less quantity. Okay. Therefore, the court will now reach findings regarding the credibility and probability findings by the court in respect of the state and the state case. Firstly, the state witness that testified before court are found, based on the evidence placed on record yesterday and the day before, to be credible, reliable, and truthful, and the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witness to indicate otherwise. Mention needs to be made with regards to the evidence of Colonel Mgwadleka. Safe to say that he was a brilliant witness and had left no stone unturned. He had dotted every T and dotted every I. He had not made any mistake as far as the custody chain or the handling of the exhibits or the serial numbers contained. The court finds him, and all the above then, as stated, credible, reliable, and truthful. However, the evidence of Colonel Mgwadleka during his testimony was checked in the working case file which the defense had insight of. And with reference to the evidence of Colonel Mgwadleka, the court has placed the procedure regarding the evaluation of expert witnesses on record already. He meets the criteria. In fact, he exceeds the required criteria in his thoroughness, and he can be, or he is mentioned by this court to be not only an expert witness but a super qualified expert witness. That is the conclusion regarding Colonel Mgwadleka. I've already dealt with the gearhouse and the admissibility. However, I want to emphasize that the further aspect regarding the laptop that was stolen and mentioned as a reason, the stealing of the laptop is a non-event. It does not affect the chain of evidence regarding the gearhouse. The gearhouse starts where it was confirmed by the employees that the hard drive was indeed depicting the correct footage they're recording. Thereafter, they clear it for space for future events. Therefore, the theft of the laptop is neither here nor there. It's not a factor this court needs to consider. Now, in dealing with the defense case, the following is placed on record during the evaluation. The evidence of Mr. Hood is noted and greatly appreciated by this court, including his extensive knowledge with regards to the provisions of Act 60 of 2000. and it is so acknowledged by court. With regards to Mr. de Klerk, as per the cited requirements already placed on record in the evaluation of expert evidence, and specifically with regards to, I emphasize, the personal knowledge of the subject stroke exhibit, he did not examine the cartridge or the said SPA 24914. Further, he had examined all the other firearms and rifles which are not relevant to this case. Therefore, it is noted, and that is the only finding I can make on those tests conducted. However, it needs to be noted that during cross-examination, the witness was indeed a defensive witness, and at stages argumentative. His evidence mostly relates as to, and then he continues stating, if I can put it more clearly, the report deals with the evidence and how it relates as to what the microscopic examination entails or should entail, and all exhibits thereafter is not relevant to the case. He states, in the matter before court, the witness testified that he used his mere eye or magnifying glass. Therefore, he also mentioned the second ballistic expert present in court. I must highlight this was a second expert was not called, so it is merely with regards to cross-examination regarding the two ballistic defense witnesses present in court is a non-event. It is disregarded as a mere statement placed during cross-examination. On evaluation of the evidence of Mr. de Klerk, the mere eye or magnifying glass can never stand or be accepted in the light of the ballistic expert witness, Colonel Mngwadleka. It falls short and can only be noted as mediocre. However, I do not imply that he is not an expert in his field, but highlight the fact that also he did not receive peer review, and at times his answers in cross-examination was extremely sarcastic, and what comes to mind was on being questioned regarding the amount of cases finalized by or examined by Colonel Mngwadleka compared to his response was, I quote from memory, good for him, consider the years of his service at SABC, and then you compare it to my years of service at SABC. And in event, the witness left the services of SABC approximately 30 years ago. That is all that can be said regarding the evidence and the defense case on behalf of accused 2. No positive findings is made in respect of the Exhibit M. With regards to accused 1, on evaluation, it was evident that the only aspect to be decided on was whether he fired a real or toy gun. The said firearm, toy or real, was indeed handed to him by Mr. Mavundla, and during his evidence he testified that Mr. Mavundla should have been charged. This begs the question, charged for what? Handing you the toy firearm, or then alternatively the SPA 249-14? The answer is nonsensical as to why Larry Mavundla should have been charged. In effect, the further particulars indicate a warning statement was obtained from Larry Mavundla as per A121. And just to elaborate on one aspect, sorry, I need to revert to the defense case on behalf of accused 2. Apologies, number 1. It also comes to mind that Advocate Matthews had put to the witness that being Colonel Mngwadleka, he had received instructions from the said protecting officer, being Larry Mavundla, that the breech block of CN SPA 249-14 has not been changed or altered in any manner. Now that statement remains a mere statement. The person on whose instructions Advocate Matthews placed this statement to the witness was not called to substantiate. Therefore, it is a mere statement done in cross-examination. It also further then begs the question, if he had left the firearm in Gauteng as stated, he cannot make such a version or instruction to Advocate Matthews, because in his version or their version, he had not possession of the firearm during that time. Now, to return to accused number 1, I've dealt with as to why he states Mr. Mavundla should be charged. He also relies on the video footage of clip 3. I mentioned this as a mere reason that it was part of his evidence, and he identifies Mavundla, who was not called to testify, and identifies Chauke. Now, when read the statement regarding identifying Chauke, read with Chauke's evidence or statement that he was not on the stage or present on the stage, leaves a question mark. During cross-examination, which I've already placed on record the aspects, the evaluation is as follows. Mr. Malema had evaded many questions that had warranted a reply. It became evident that the replies were entertaining, but however, the pertinent questions asked remained unanswered. He further relied on clip 3, and he had then counted 15 shots fired, and thereafter stated he cannot count, he had graduated in woodwork. Further, as to how the cartridge or the SPA 249-14 is linked to him, his reply was it must have been the Holy Spirit, and these type of answers did not do accused one any favors. In essence, when one is questioned in the witness stand and a mere question is asked from you which elicits a response, one would expect that the question will be answered. Therefore, the court needs to deal or to establish whether the version presented by the defense is reasonably possibly true. I have already stated all the factors that remain intact, excluding the video clip 3. Just a minute. You put me under pressure with this time limit, so I just need to sort out my documents here. Alright, now the court will proceed with the findings made in this matter, and as stated, the findings are based on the rules pertaining to circumstantial evidence, keeping in mind the two cardinal rules already placed on record, but which the court will repeat at a later stage. Firstly, the inference, or it can be said that all the relevant persons as per the evidence of this entire case were in East London, that the firearm booked to Mr. Mavundla was, according to him, not in his personal possession, but no explanation has been given as to where it was kept in Gauteng. The registers of the KZN unit indeed states it was booked out to Gauteng Larry Mavundla. But where was it kept since 28 July or since his departure in Gauteng? Mavundla, through Advocate Matthews, informed him that the breech block was not changed or altered. And now if he left the SP 249 in Gauteng and came to East London, it was not in his personal control as stated. However, the question is seen as a mere question put during cross-exam and remains just that, a statement in cross-exam. Therefore, the person who informed Advocate Matthews of this fact then should have been called, and he is in no position to give such information since it is his version of the defense that the firearm was in Gauteng. Now, as to what happened and where it was kept, no explanation was provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavundla in effect equates to? That specific firearm is booked out to him for whenever it is needed for him or by him, since clearly it does not mean it needs to be on his body since he left it in Gauteng. Further, on considering those aspects, why would the two firearms in question be called in and said please take this for ballistic testing? However, the others that were booked out in the register was not brought in on the day Colonel Jansen left on the 6th. Just the two in question. Further, the court is obliged to look at that the said cartridge was found, as the evidence was accepted of Colonel Mgwadleka. It was matched with SPA 249-14, and the conclusions on the record by Mgwadleka have already been placed on record. And since I'm pressed for time, also further, accused one says he is the only person who fired an object resembling a firearm, no one else. The grounds were inspected the morning of the event and no cartridges were found, and the area was declared safe. Therefore, the two cardinal rules for the court to draw inferences on the evidence presented, and which I have now stated on record as a reasoning as to the reasons why the court has arrived at its decision. I remind you the cardinal rules being, firstly, that the inference sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts should be such that they exclude every reasonable inference from them save the one sought. In this instance, the question or the pertinent question then remains, whether the court can infer, based on the reasons placed on record, including the evidence that it had dealt with over the last 2 days, whether such inference can be made, and the court finds as follows. Indeed, the inference sought is supported by all the facts contained as per the evidence presented in court, and therefore the following findings are made. You may stand up, accused 1 and 2. Accused 1, in respect of counts 1, 2, 3, 4, and 5, you are found guilty as charged. Accused 2, Mr. Snyman, in respect of counts 4 and 6, you are found not guilty and discharged. You may be seated. Okay. At this point, the court will then just... Is there something you wanted to place on record?
Yes, Your Worship, I just want to say accused number 1 is no previous conviction.
Same is noted.
Just that because of the shortage of time, my instructions are to apply for postponement and for the continued release of the accused on warning. He's been on warning since the outset and has always appeared at court.
The court has no intention of changing the status of your client, Advocate Ode, so I am completely in agreement with that, and further that it's not possible to deal with the rest of the proceedings today.
Okay, we should just speak to that. In that regard, Your Worship, it's our intention to obtain a pre-sentence report, and for that purpose we need to arrange a date with Your Worship.
Okay, so at this point, just so that you may have a word with your client regarding his schedule. Of course, Advocate Matthews, you are now excused from record.
I'm going to catch my train.
Yes, it will take you about a decade or so.
Could I just say something to you?
Yes.
I just want to thank you because you have been very patient with it. And you have, on many occasions, allowed the case to continue without us being present.
Thank you, Advocate Matthews. It's much appreciated. Mr. Snyman, it will be your choice whether you stand down and leave Mr. Malema or if you want to remain seated next to him. That will... Sorry? All right, I assumed as such. Just to take instructions regarding the time frame, suitable date, whatever I have on a specific day, obviously I will have to clear or deal with as I had to do yesterday and today. So may I leave you with that arrangements and then return? It's 20 to 11. We'll return by 10 to 11. Is that in order? In order. Court will adjourn. Okay, let me just endorse the charge sheet. I'll hear from you now, Advocate Hoders and Caesar, as to what was said. I just need to endorse it on the charge sheet. Is going to opt for the pre-sentence report route. I just want to endorse that is still the position on the record. I have endorsed Advocate Caesar, no previous convictions, in case you wondered if I have endorsed it. Advocate Hoders, may I just inquire on this pre-sentence aspect? Will it be, you be following the normal route that is followed, or will you be using your own? I just, okay.
The signals very worship, but I've attempted to get hold of Mrs. Thompson, that's what she's doing, and qualified with an adult between social work.
The reason why I'm asking is merely so that the clerk of our court may know whether she should prepare a request for the normal route, but now that has been ruled out and the defense will do so on its own. That is
responsibility for the compilation of the pre-sentence report. My little friend has also approached me to assist in that regard, Bishop, and asked the accused details and explained to me it was necessary to pursue our own private social worker to present a pre-sentence report.
Have you come to anything else, sorry?
To that end, Your Worship, subject to Your Worship's permission, we agreed to the date of Friday the 23rd of January 2026. That would provide sufficient time to compile the report and consider our respective advice. I don't know if Your Worship.
I don't have it with me, but I know January starts quietly because practitioners are still, and legal aid is on vacation, but I do have a matter, but I can deal with it and accommodate this matter as I've been doing, so it's not a problem.
That's truly appreciated.
Thank you. The date suitable for the State Advocate, Caesar? Alright, Mr. Malema, the matter is then postponed. Huh? Not procedure, but fine. And then if you're fine, I'm fine. The matter is postponed to the 23rd of January for the pre-sentence reports. Now, in this regard, I want to place on record, I am not sure as to whether the defense, being Advocate Hoders and yourself, will be leading evidence or calling witnesses in that regard, and then the state to address. So, depending on how much time is utilized in that process, I cannot say sentence will be pronounced on the same day. It depends on what you will be presenting before court on that day. Therefore, bail extended, warned 9 o'clock to proceed, 23 January 2026. Thank you. The court is adjourned. Then I will continue with my normal role for the day. Thank you.